Welcome to California Bar Prep, your study companion for the California Bar exam. In this lesson, character evidence and impeachment. Let's begin. Character evidence asks whether a person acted a certain way because that is the kind of person they are. The law is suspicious of this reasoning because it invites punishment for status rather than proof of the charged event. Impeachment is different. It attacks whether a witness should be believed. The bar exam blurs these categories by offering prior crimes, lies, violence, drug use, bias, and reputation evidence. Your job is to classify the evidence by purpose. On the MBE, the federal rules control. In California, the evidence code often tracks the federal approach, but Prop 8 makes many relevant impeachment and character items admissible in criminal cases unless a preserved exclusion applies. Always separate civil from criminal and propensity from non-propensity. General propensity rule. Evidence of a person's character or character trait is generally inadmissible to prove that on a particular occasion the person acted in accordance with that trait. Criminal defendant exception. A criminal defendant may offer evidence of a pertinent character trait. Under the FRE, this is usually reputation or opinion evidence. If the defendant opens the door, the prosecutor may rebut with reputation or opinion evidence and may cross-examine the character witness about relevant specific acts. Victim character. A criminal defendant may offer evidence of a victim's pertinent trait, such as violence, to support self-defense. The prosecutor may rebut and, in a homicide case, may offer evidence of the victim's peacefulness to rebut evidence that the victim was first aggressor. Civil cases. Character evidence is generally inadmissible to prove conduct in conformity unless character is directly at issue, such as defamation, negligent entrustment, or child custody. When character is an essential element, specific acts, opinion, and reputation may be used. Other acts, crimes, wrongs, or other acts are inadmissible to prove propensity, but may be admissible for motive, opportunity, intent, preparation, plan, knowledge, identity, absence of mistake, or lack of accident. The court must still balance prejudice and may give a limiting instruction. Character analysis. Identify the trait. Identify the purpose, propensity or non-propensity. Identify the case type, civil or criminal. Identify the form, reputation, opinion, or specific acts. Apply balancing and limiting instruction. Impeachment methods. Bias, always relevant. A witness may be impeached by bias, interest, motive to lie, plea deal, family relationship, hostility, payment, or fear. Prior inconsistent statement. A witness may be confronted with an inconsistent statement. Under the FRE, extrinsic evidence is allowed if the witness has an opportunity to explain or deny, and the opposing party can examine the witness, unless justice requires otherwise. If the statement was made under oath at a trial, hearing, proceeding, or deposition, it is also non-hearsay substantive evidence. Convictions. Under the FRE, felony convictions may impeach subject to balancing. For a criminal defendant, probative value must outweigh prejudice. For other witnesses, exclude only if unfair prejudice substantially outweighs probative value. Crimes involving dishonesty or false statement must be admitted, subject to the 10-year limit. Old convictions more than 10 years from conviction or release are admissible only if probative value substantially outweighs prejudice and notice is given. Bad acts. Specific acts not resulting in conviction may be asked about on cross if probative of truthfulness, but extrinsic evidence is not allowed under the FRE. Lying on a job application may qualify. Assault usually does not. Reputation or opinion for truthfulness. A witness may be attacked or supported by reputation or opinion evidence concerning truthfulness, but support is allowed only after an attack. Sensory defects and contradiction. A witness may be impeached by inability to perceive, remember, or narrate, and by contradictory evidence if the contradiction is not collateral. California character forms. California traditionally limits character proof to opinion, reputation, and specific instances depending on context, with statutory rules. In criminal cases, a defendant may offer character evidence of the defendant or victim, and the prosecution may rebut. California is more receptive to specific acts in some victim character self-defense settings than the federal shorthand suggests. Prop 8 and impeachment. In California criminal cases, Prop 8 generally permits all relevant impeachment evidence, including misconduct involving moral turpitude, subject to Section 352, hearsay, privilege, and constitutional limits. Moral turpitude means a readiness to do evil and includes many crimes involving dishonesty, violence, or serious antisocial conduct. The court retains discretion to exclude remote, cumulative, or highly prejudicial impeachment. California felony impeachment. California does not mechanically follow FRE 609. The key phrase is moral turpitude, plus Section 352 balancing. For criminal defendants, courts are careful about similarity to the charged offense, remoteness, and whether admission will deter testimony. Rape shield. California has detailed sexual conduct restrictions. Evidence of a victim's prior sexual conduct is heavily limited, though evidence may sometimes be admitted for credibility or to prove consent after statutory procedures. Federal rules also restrict sexual behavior and predisposition evidence. Prior acts offered for identity require a distinctive modus operandi. Mere similarity is not enough. Intent and absence of mistake are strongest when the defendant claims accident, ignorance, or innocent state of mind. A character witness may be cross-examined about specific acts to test knowledge, but the acts are not proved substantively. Extrinsic evidence of a collateral contradiction is usually inadmissible. Bias is never collateral in the same way. A prior inconsistent statement may impeach even if hearsay, but it is substantive only if a hearsay exclusion or exception applies. Evidence that a person was careful on many prior occasions is usually character, not habit. Habit requires regular, specific, semi-automatic conduct. On the MBE, ask, is this about the party's conduct, the witness's credibility, or a non-propensity issue? If the answer choice says inadmissible because character evidence, check whether the evidence is actually offered for motive, intent, identity, bias, or truthfulness. If the answer choice says admissible to show bad character, be suspicious. On California essays, include Prop 8 when the case is criminal. A strong answer says, this prior misconduct is relevant impeachment because it involves moral turpitude. Prop 8 favors admissibility. The court still applies CEC 352 and may exclude if undue prejudice, remoteness, or confusion substantially outweighs probative value. That single sentence captures the California distinction. Note: character evidence is a purpose problem. Impeachment is a credibility problem. Keeping those boxes separate prevents most wrong answers. That's it for this lesson. Download California Bar Prep on the App Store for lessons on all 14 bar subjects, practice questions, and essay frameworks. Keep studying, and good luck on the bar exam.